You are watching day 6 of After the Trial, a streaming show we have here on WFAA+. We have special coverage of this track meet stabbing trial. Karmelo Anthony is charged with murder in the death of Hunter Metcalf. We have an awesome panel here. First of all, breaking news, both the defense and the state have rested their cases. There will be no new evidence presented to this jury. We have Bree West, you've done defense work, you've been on the state side. Today you're going to be playing both sides for us if you can.
Absolutely.
And then we have Rebecca Lopez, senior crime and justice reporter. Yeah, there's a lot of, court feels like a lot of hurry up and wait, and then a lot of stuff happens.
Right.
And a lot of stuff happened just in the last 2 hours.
Yeah.
And I think the biggest part is Karmelo Anthony, the defendant, did not testify.
Correct. I also think that it was a surprise to many court observers that the defense rested so quickly. I anticipated at least a few more witnesses, and also whether or not that was the big thing that was hanging over this trial, whether Karmelo Anthony would testify or not.
That's right. And I think that when we were in the courtroom sort of anticipating the defense picking their case up again, I think many of us thought that, okay, well, now Karmelo Anthony is going to get on the stand. That's what we've been waiting for. Everybody is ready to hear his version of the facts and sort of his position as it relates to self-defense. And there was almost, I won't go as far as to say there was an audible gasp in the courtroom when they said, "Ladies and gentlemen of the jury, Your Honor, the defense rests." Yeah. But there was almost an audible gag. People were shocked. It seemed to come out of nowhere. Nobody anticipated that. I think most people thought that Karmelo Anthony was going to testify. And I think that you, Rebecca, kind of pointed out that a lot of people just wanted to hear what he had to say because there's been so much buildup around the self-defense. And to hear that from him, I think a lot of people thought, surely the defense is going to do that.
When we came out, people that were spectators out here were like, why isn't he taking the stand? Why isn't he taking the stand? I heard that from people on both sides. And because honestly, he's the only one that can sit up there and say why he feels that this was self-defense. But as a prosecutor or a defense attorney, why would you not put him on the stand?
And I think that one of the big things about having a 17-year-old client that's charged with an offense like murder, it's beyond just telling a story. It's ensuring that client, that charged defendant can hold up against a cross-examination from prosecutors that have been practicing and doing this for more than 30 years. These are seasoned, outstanding prosecutors. I think all of us witnessed, sort of how they pepper witnesses with questions, how they're very prepared, and whether or not Karmelo Anthony's story was outstanding through the direction of his criminal defense attorney, was it going to fall apart on cross-examination, and would that have hurt him in his case? And that's really the analysis that defense attorneys have to make. Can you withstand cross-examination, and is that going to hurt us, or is it going to help us? And I think that obviously here, that analysis was, we don't need to do this.
It's important to mention Bill Werski is... that's facing a lot of scrutiny. That's a lot of scrutiny that can come your way.
That's right.
Because he's a seasoned attorney.
That's right. And the entire prosecution team. Those are attorneys that have been practicing, most of them, I think, 20 plus years. And so this is very serious. And this was something that you really had to analyze. this is a really kind of a question of life or death. We're not dealing with the death penalty at all, but I'm just saying, you could face life in prison if you're convicted of murder.
Bree, can you give us some of the context clues? Because there were some delays. Judge Roach runs a really tight ship, right? It's 9 a.m. to 6 p.m. every day. Okay. But in the last 2 hours, there were delays, there were sidebars, there were people walking in and out of the courtroom, family coming in and out. What were some of the context clues that told you, okay, a big decision is about to come your way?
Well, I think you'll remember the very first clue that we had is we took an early lunch. Mm-hmm. Oftentimes what you see when you're taking a lunch sort of out of the normal hours is something is happening. Either there is a big giant witness that's coming and they don't want to start and then stop after 10 or 15 minutes, or there's some kind of other sort of, we need to take something up outside the presence of the jury, let's spend this time doing it. So our first clue, Job and I think, was we took an early lunch. Okay. And then as we're sitting there and they're making a decision about taking an early lunch, we see that all of the attorneys go up to the bench and they do a sidebar. They have a white noise machine, and that's to make sure that we in the gallery, you're very familiar with this,
right.
Rebecca, we can't hear what they're being, what they're talking about, which is intentional and it's important. And we saw sort of the defense team go up, have a conversation at the sidebar, walk away from the bench, go into their little workroom, come back. I mean, and it was you were like, something is getting ready to happen. And then all of a sudden they came back and said early lunch. And so I think that was huge. Yeah. That was an indication that something major was coming. And I have to be honest with you, I kind of thought that it was the setup for Karmelo Anthony testifying.
Yeah. Right. And then we also at some point were speculating maybe they were working out some sort of plea deal. But there were also, we saw Karmelo Anthony's mom and dad go into the courtroom, and you saw her distraught.
Yes.
And then what was the demeanor when they all got in there between both the Metcalf and Karmelo Anthony's families?
I'm glad that you asked that question, because remember, Rebecca, we saw both Karmelo Anthony's mom and dad coming into the courtroom while we were on a very unexpected extended lunch break. And I think that was another clue that we said, well, what's really going on? I mean, I think we ended up having a 2.5-hour lunch, which is extremely unusual, especially in a court.
In this courtroom.
Where you have a judge that doesn't play around. So when we walked in, finally, after I think 2.5 hours, very unclear about what was getting ready to happen, I walked in personally. I certainly saw Karmelo Anthony's parents looking, sort of very serious, very somber. And I also walked in and I saw Karmelo Anthony look, sort of sitting straight ahead, very serious, very somber. And I saw Mike Howard put his arm around Karmelo Anthony before things got started. It looked like he said something to him. Yeah. I don't know what he said.
So does that tell you this decision happened probably during that break? And let's clear the air here. This decision is not Mike Howard's decision or Toby Shook's decision. Whose decision is it to testify?
I'm so glad that you asked that question. 100% the decision of Karmelo Anthony, not his parents, not his attorneys. It is only him that can decide whether or not he wants to get on that stand and testify in his own defense. And so, I mean, I do think always in any defense case, whether or not your client testifies is a game time decision. You cannot you can have an idea, but you cannot make that decision beforehand because you don't know how the trial is going to go. You don't know what witnesses are actually going to come in, what evidence is actually going to be admitted, what you actually are going to have to challenge inside of your defense case. And so you cannot say, okay, for sure, 100%, my client is going to testify. You can't make that decision ahead of time. So I agree with you, Jobin, that the decision on whether or not Karmelo Anthony was going to testify, him making that decision alone, literally took place in those 2.5 hours.
Yeah, but what did you make of all of that? Because at the last minute, this defense team, brought in several witnesses that to me were not like aha witnesses. Don't you want to end your case typically on a very, very strong witness, which I guess in this case would have been Karmelo Anthony? How do you think about the way that the defense ended their case?
So I don't think that necessarily the defense team anticipated that he wasn't going to testify. I mean, you have to have a plan going into your defense case. And so undoubtedly they had a plan. They're saying self-defense. Generally speaking, you say, okay, you're going to testify if we're going to raise self-defense. It's not required. You try not to, but you plan for it. And so I think that was their plan even as late as yesterday. Not yesterday, Saturday, when they put on their initial witnesses. I think that they were leading up. They had a day off, which I think was really good to try to really prepare right beforehand. And I think that ultimately it seemed to me that they put on the 2 juvenile witnesses and 1 detective witness, very short witnesses, all 3 of them. They finished them in probably an hour together, and that their next big thing was going to be Karmelo Anthony. And they weren't necessarily, even as a team, expecting that he was going to ultimately decide that that's not what he wanted to do.
And the next big person that we thought was going to take the stand is Hunter Metcalf. This is Austin Metcalf's twin brother. Do you think them not calling him up in the rebuttal was contingent upon Karmelo Anthony testifying?
I absolutely think so. I think that if Hunter Metcalf was going to testify, it was going to be for the sole purpose of rebutting the version of the facts that Karmelo Anthony testified about. And because he didn't testify, there was no need to put Austin Metcalf. Now, I'll also say that as a prosecution team, you have more of a responsibility not only to the facts and the evidence, but you have a responsibility to your witnesses. And you're dealing with another 17-year-old who has experienced unimaginable tragedy and lost his twin brother and all of these kinds of things. And so putting him on the stand is a whole analysis within itself, because you don't want to destroy that young man further. And so I do think that part of what the prosecution did was say, we don't want to do this, and we're sort of thankful that we don't have to do it.
Yeah, because I was talking to people that were out there that knew the Metcalf family, that have been talking to the mom, that have been talking to the family, that said he absolutely did not want to come to court. He did not want to relive the most traumatic moment of his life of losing his twin brother, that it was going to be very traumatic for Hunter to take the stand. So, yeah.
So now, tell me about the process here. The judge is right now in an informal charge conference with both sides.
That's right.
What does this process look like? And this is when these lesser charges get introduced. Let's talk manslaughter.
Yes.
So what is this process? Usually you're saying that it does happen in the open, or they don't happen in the open.
So really sort of the informal charge conference is really more about the fact that it's just not on the record. Right now, they're all just having a discussion, all of the attorneys. I would say that the defense is saying, here are the things that we want in the jury charge. Let's have a sort of informal, off-the-record conversation about that so we can speak freely and openly about why we think these things should be included in the charge. I think that they're going to absolutely argue for self-defense to be included in the charge and for the lesser offense of manslaughter. They may argue for other lessers. We don't know. I know that during voir dire, they talked about other lessers, but you can't just put them in because you want them into a jury charge, right? Everything has to be supported by the facts and the evidence that was raised at trial. So whether or not there was additional information beyond, say, recklessness, which would support manslaughter, I don't, that's really an argument for the defense to make.
So there's two train of thoughts here. Some defense attorneys want manslaughter because it would be a lesser sentencing. However, some may not want it because they want to force this jury to vote guilt or innocence on a murder charge. So which way do you think this defense team is leaning, and do you think Judge Roach, because he ultimately is the one that makes the decision, would add manslaughter as a lesser offense here?
I think in facts like these, with a client that is as young as Karmelo Anthony, there's no way that you don't argue for a lesser offense. It's a huge risk if you leave it out to say, oh, I do want to force somebody to make a decision, but in the event that they get it wrong, I don't want this young man to be convicted of murder, facing 5 years to 99 years or life in prison. And so I think under these facts, you fight tooth and nail for manslaughter to be included. Now, with that being said, you still have to make the argument that some kind of reckless action, reckless behavior, reckless sort of mental state was raised in the facts and the evidence throughout the trial, right? And so I think that what the defense is going to be doing is they're going to be arguing to say, Judge, you heard from this witness and this witness and this witness, and all of those witnesses testified about the reckless nature of this act. That supports the inclusion of manslaughter into this jury charge. So we think it should go in. And I'm not a judge. That's maybe next up for me, but I think that if I'm a judge, I'm erring on the side of caution. I am including a lesser offense of manslaughter in that jury charge, and I'm giving the jury the option to consider everything that they heard and decide what bucket that fits into.
For appellate reasons?
Absolutely, for appellate reasons.
Right. Okay, because Rebecca and I are not attorneys. Yeah. You're the only attorney on this stand.
Although Rebecca's honorary attorney.
She's done enough work over the last 25 years. Can you give us the quick 30 seconds for our audience? Difference between manslaughter and murder?
Thank you. Okay, so the difference between manslaughter and murder is the intentional or knowing killing of another person, whereas manslaughter is the intentional, knowing, or reckless killing of another person. The biggest difference between the two offenses is the range of punishment if you're found guilty. If you are found guilty of murder, then your range of punishment is anywhere from 5 years to 99 years or life in the penitentiary. But if you're found guilty or plead to manslaughter, then your range of punishment becomes 2 years to 20 years confinement in the penitentiary, but you also are eligible for probation, which you cannot receive probation on a murder conviction in the state of Texas under any set of circumstances.
And for the jury to consider self-defense, we keep saying scintilla of evidence. Explain that for our audience if you can.
The smallest amount.
The smallest.
Any amount of evidence that could support a reasonable trier of fact to conclude that maybe somebody acted with justification should get self-defense included into your jury charge for consideration. Now remember, self-defense being included in the jury charge doesn't mean that the jury has to find self-defense, right? They can look at it and they can all say, we absolutely don't think that self-defense applies here, and they move on.
But when we're also talking about intent for murder, it's not just he was going to that track to stab somebody. Intent can also be in that moment, correct?
That's right.
To prove murder.
That's exactly right. Remember, intent can always be formed in an instant. Now, I think the long version is that you potentially would believe, if you thought he was guilty of murder, you would potentially believe that he headed to the track meet, that he decided at that point that he wanted to go. He took the, whatever kind of weapon with the intention of causing death while there, right? But the other part, the shorter part of that argument is once he arrived, that he then was involved in a situation where he then instantly created the intent to cause death. And I think that's a heavy lift on the part of the prosecution. I think that's a hard thing to show. And so it's going to be really, really difficult as it relates to the jury sort of thinking about those things.
How much does his emotion afterwards, the fact that he said, I don't think he's going to die, and he also said, was that self-defense, and some of almost the remorse he showed immediately, how much does that come into play when it comes to that?
I think that's the human part of this, right? And I think sometimes we get, it's so easy to sort of be caught in the black and white nature of a crime, that it's easy to lose the humanity in it. And the humanity of this trial is that these are two 17-year-old kids. And I think that the emotion that he showed after the fact, the tears that he showed, the fact that maybe he didn't believe that that the victim was going to pass away, I think all of those things show sort of his age, his immaturity, and the humanity of the tragic situation that I think all of this represents.
So the judge told this jury to go home. We're going to deliberate tomorrow, but pack a bag.
Yes.
Let's talk about a sequester.
Yes.
That's for their safety. And why hasn't that been something why weren't they sequestered throughout this trial, do you think?
I think that's a really interesting question. I just from a taxpayer standpoint,
Sure.
Sequestering a jury for the length of a trial plus deliberation is a astronomical cost. And I do think that a judge has to weigh that. I know that in other cases that Rebecca and I have worked on, that's been a discussion, and it's really usually not during the trial testimony, but maybe only contemplated during deliberations. I think in this particular case, the media frenzy that's surrounding these allegations, the two young boys, sort of the track meet, the community that we're in, all of that, I think, has hit the internet in a way that is really challenging. I think that the trial not being televised or live streamed has created this space for anyone and everyone to make up whatever's going on. I think, Jobin, you and I talked about the fact that we've seen AI images of what the courtroom looks like.
Would look like, yeah.
Or who, what the people in the courtroom look like. And so, and that's completely made up. And so everybody's opinions are completely made up. And I think that what the judge said, and I think you heard this too, Jobin, is that he said, for the love of God, don't look at social media. And I think the point of that was, don't get caught in that rabbit hole of misinformation, and allow it to influence your decision. This is a huge decision that this jury has to make. There are such significant consequences on both sides, whatever it is that they decide, that this should be a time where the jury can be completely focused without the interference of social media or friends or family, or this is my opinion, or this is what I think. And I think that the judge's call about potential sequestration is exactly right as it relates to deliberations.
And it's important to note that this isn't your everyday kind of hotel. There are no TVs inside this hotel.
That's right.
So that you're not forming or watching more coverage of this.
Yeah, they take everything from them too. They can't have phones. They can't have anything. And that's typical. You cannot have a television or anything in there that would in any way allow them to see anything that is happening in the outside world. And that's to keep the jury, fair and impartial.
Okay, Rebecca, I want to ask you this question. Tomorrow we have closing arguments. What do you want to hear from the state and the defense? They're both, so that the defense is sandwiched in between the state on they'll get the first and the third chance on this thing, and then that's when the jury deliberates. What do you want to hear tomorrow morning?
Well, they're going to summarize their cases, and they're going to bring forth their best, what they believe that the evidence was that's going to prove their case. And so I suspect it's not necessarily what I expect, what I want to hear, but I think more what I anticipate is going to happen. I mean, Bill Wurtsky is going to be very strong. He's a very strong prosecutor, and he is going to come in and say, this was murder, this family, this man killed this young kid, this family has suffered, the community has suffered, and it was, all out murder. What you're going to hear from, I believe, the defense is going to be, he was fearful. There was a lot of chaos, the chaotic nature, the fact that the knife wasn't completely folded when they found it. All of that is going to come into play. And
while also humanizing Karmelo
Anthony, and also, again, reiterating what we saw on those tapes, and that is he is crying. He doesn't realize at that moment that, at least that's what it appears, that he, didn't realize that he was Austin Metcalf was going to die.
Now, Bree, I'm sure closing arguments is probably a law class all by itself. What tone do you want to set for both sides?
So it's interesting, just kind of piggybacking on what Rebecca said, sort of from the prosecution standpoint, I think that in this particular case and under these particular facts, I do think that the prosecution is going to argue heavy for find him guilty of murder. This was intentional, this was intentional, this was intentional. But I think a smart prosecutor is going to say, but if you don't think it was an intentional act, you certainly know it was reckless. Mm-hmm. Because I think that the prosecution is going to say, but don't find him not guilty, right? Like, I think that would be the thing that they would really be pushing for. I think heavy on the intentional act. But I think the backup argument for the prosecution is this was reckless, find him guilty of manslaughter if you're not going to find him guilty of murder. On the flip side, I think that the prosecution literally is doing the exact opposite. You know that was a chaotic scene. You heard all of these witnesses. Everybody had a different version of what happened and where people were standing and how this and how that. And even the people that came and saw the video of it after that didn't match the statement that they wrote at the time. Mm-hmm. That's how chaotic it was. That's how traumatic it was. That tells you everything you need to know about why somebody would need to act in self-defense, why the death, right, is justified in some way. I think it's important that the defense acknowledge the absolute tragedy in this situation. This is not, these are kids, and this is tragic from every angle. And I think that if they don't acknowledge that, they really miss something significant. Yeah. But I think that ultimately they should push for the self-defense, finding him not guilty based on self-defense. And then their secondary argument is, but if for some reason you don't think that this killing was justified, or you don't think that this action was justified by it being reckless, then justified and therefore finding him not guilty, then at a minimum, you know that it was reckless.
Do you think Mike Howard and Toby Shook will split their time and both end with their closing arguments?
So I generally find that when you have a two-person defense team, you always want to split your time, mostly because you each have a different strength, right? And so whatever those strengths are between Mike Howard and Toby Shook, I think that they're going to split to say you cover sort of the elements and why this is important, and I'll cover the emotion, or vice versa. And I think that it's nice to have that come from two different people. But we'll see with them. I know that Mike Howard has done an outstanding job. I know that Toby Shook did a phenomenal job on the jury side. So we're going to see how they split it, but I think usually that's what you see.
And then,
I know that.
And then for the state, Bill Werski.
Right. I was going to say you generally see the state for sure split.
Yeah.
Right.
Yes.
I think that it should be. I mean, generally speaking, it would be between Bill Werski and Dewey.
Yeah.
Mm-hmm.
But I know that they have a third person on their defense. I mean, on their prosecution
Christina Skipper.
team.
Yes.
So I don't know. Do you want to add some emotion and allow sort of a female prosecutor to talk a little bit about, the victim?
We have 2 minutes left. I want to ask you, are you surprised? I'm sure you're surprised by a lot of things with this trial. Are you surprised by the very aggressive timeline we have? We've only heard 3.5 days of testimony for a very high-profile murder trial.
Right. I'm not. I think that because it's high profile, they should have tried to speed up this timeline. Oh. The more time that we spend on a trial, the more sensationalized, the more outside influence exists. Yeah. And I think that the best thing that honestly the defense and the prosecution could have done is to say, no. Let's be razor sharp here, and let's make sure that we get this done and get this out of the public.
And while this is a high-profile trial, it is not atypical of a murder charge and a murder case. You see this typically, it lasting a week, both prosecution and defense, and then possibly going into sentencing. But I've never really seen cases other than the Tanner Horner one that we just recently did that went like a month. But typically they are pretty quick, most of these cases.
I want to end with, so we don't have any cameras inside this courtroom, no streaming, nothing, which is the reason we have all this happening. But we also have Pat Lopez, who has been our sketch artist, an awesome sketch artist who has done a lot of high-profile trials and is doing this one. I want to show this first image. Can you, Rebecca, speak to what it is we're seeing here? This is the full courtroom.
So I don't have my glasses, Jeb, and I actually cannot see that. So maybe Bree can see it a little bit better. It looks like it's the defense team.
Yeah, so it's sort of an angle of the courtroom from sitting to the sort of far right of the courtroom, and so you're looking towards the defense table. The prosecution table is next to them, and the jury is in the far back corner. Yeah. And so what we're seeing in this image, which by the way, this is unbelievable artistry. I was in the courtroom while she was sketching some of this, and it's phenomenal. But you're seeing Toby Shook, Karmelo Anthony, and Mike Howard, and then you're seeing two of the prosecution attorneys, and then obviously like no face jury. But that's an outstanding depiction of kind of what things look like.
And that is, and we'll see this again tomorrow.
Okay.
We'll have more sketches tomorrow as well, and we'll hear what we can expect is some powerful closing arguments from both sides.
Yeah, and I think that this will probably go to the jury before noon tomorrow. And then deliberations. Guessing what a jury's going to do, I've stopped doing that years ago because you have no idea. Yeah,
and we should never guess.
Yeah.
We just wait till it happens, and that's that's really been our calling card this entire trial. Right. Anything you want to say in terms of when you think this goes to the jury? I completely agree with her. I think that it's going to be with the jury by noon. And they're going to be able to deliberate. And I think one of the other things that the judge said, to try to avoid the sequestration if he can, he did say, we'll stay here as long as you want. We'll stay here till 10 o'clock at night if you think you can reach a verdict. And I think that that's the right thing to do. Bree, it was great having you. I appreciate you for all of your legal expertise. And Rebecca, it's always great having you as well. You are watching Day 6 of After the Trial. We'll be back here tomorrow.